The Canadian Intercompany Arbitration Agreement is a national agreement that enables insurance companies to resolve subrogation claims between themselves. It is managed by the Canadian Insurance Claims Managers Association, known as CICMA. It is a fast and cost-effective way of resolving disputes between insurance companies. Because the process is less formal, the speed from application to resolution is quick. That speed, in addition to not requiring counsel, results in both hard dollar savings and legal expenses, and soft dollar savings in the fact that less time is spent examining and directing counsel on the part of the claims department's employees. Only insurance companies can be signatories. The Insurance Bureau of Canada, IBC, keeps track of all insurance companies who are signatories to the Intercompany Arbitration Agreement. The list can be accessed via the IBC's website at www.ibc.ca. If you need to know when an insurance company became a signatory company, please contact the IBC at this address. Insurance companies that are signatories to the agreement must use it to resolve certain types of disputes between them. Claims that must go through this process are physical damage subrogation claims arising out of accidents and insured events. The losses occur only in Canada. Business interruption claims arising from the physical damage claims are included. There are certain disputed claims that insurers are not bound to the Intercompany Arbitration Agreement for. However, if the insurers agree, the dispute can be resolved through this process. 1. If one of the insurers is not a signatory of the agreement. 2. If litigation was commenced prior to one of the insurance companies signing on to the agreement. 3. If an insurance company indicates a lack of coverage as a reason for not paying a claim. 4. If the claim involves boiler machinery, aviation, or ocean marine. 5. If the loss did not occur in Canada. And 6. If the loss is in excess of the dollar limit. There's a dollar limit which is based upon the amount stipulated in the IBC claims agreements, formerly named Agreement Respecting Standardization of Claim Forms and Practices and Guidelines for the Settlement of Claims, as found on the IBC's website, www.ibc.ca. For quite a few years, that limit has been $50,000. However, as stated earlier, with mutual consent, amounts valued claims can be arbitrated. Arbitration decisions are not binding on amounts that are self-insured by other parties, such as deductibles and other non-insured portions of claims. However, insurers can include the deductibles in their claims and reimburse insureds for those deductibles if successful. The policyholders of the insurance companies are not allowed to arbitrate themselves, even if their insurance companies are signatories to the agreement. Prior to applying for arbitration, each insurance company must appoint a pre-arbitration officer, and the dispute must go through pre-arbitration discussions. Pre-arbitration officers must be senior members of the claims department. Usually they are supervisors or managers or technical leads of the claims department. These discussions are held without the involvement of the CICMA. If a dispute is not resolved with those discussions, then an application for arbitration can be completed. As the insurer applying for arbitration, you would complete the arbitration application as found on the CICMA website, www.cicma.ca. This is presently an e-form. Once you complete this form, a PDF form is created that can be printed. Eventually, the arbitration process can be done through the CICMA website, but this function is currently in development. The applying insurer should make their position clear as to liability as well as the extent of damages. They attach copies of whatever their evidence is to back their position, and send the same to the arbitration chair of your local chapter of the CICMA along with your filing fee, which is currently $200. You can find out who the arbitration chair is from the CICMA website, as well as what the fee is for applying. The fee is quite reasonable, and as such, the cost to arbitrate is very low. If you do not include the filing fee with your application, then the application is not deemed to have been accepted, and if you are faced with a statutory limitation argument, then you have not protected yourself from an expiring limitation period. A copy of your application and evidence should also be sent to the insurance company you are subrogating against. If you are the responding insurance company, you need to complete your section of the application outlining your position. If the responding insurer has a dispute with both liability and the damages being claimed, then the position should be made very clear. A lack of response in any area could be construed as acceptance, not having a dispute over an issue. Within 30 days, a copy of the application, which now has your response included in it, needs to be sent to the arbitration chair of your local chapter of the CICMA along with any evidence you intend to rely upon. Copies of the application and evidence are also sent to the insurer applying for arbitration. The responding party need not pay any filing fee unless they are including a counterclaim. Then they too must pay the fee. Remember, although this is a less formal dispute resolution process, legislation must still be taken into consideration. Some points to consider are: legislation still applies. This includes limitation periods, rules of the road, common law principles, etc. You still need to prove your case. Hearsay evidence is not enough. You will want to highlight court cases you are intending on relying on to back up your position. If an applicant wishes to withdraw the application because the file is settled, the applicant should notify the arbitration chairperson and the fee is not refundable. There is a national arbitration chairperson who is part of the CICMA. The local chapters of the CICMA also have an executive member who has responsibility for arbitration, and they report into the National Arbitration Chairperson. These individuals are selected by the CICMA and may sit for a period of 1 year or longer. They have a number of duties, which include verifying pre-arbitration discussions have been held on individual cases coming to arbitration, following up for missing material or information on cases, setting up arbitration panels to review disputes and make decisions on same, distribute results, respond to questions, and assist insurance companies with their arbitration questions and issues, and compile arbitration statistics from all chapters in order to produce an annual report. If the signatory company is not conforming to the procedures outlined in the intercompany agreement, the head office of that company is contacted by the arbitration chairperson. An arbitration panel will be set up consisting of a panel chairperson and 2 others. All who sit on the panel are members of the CICMA. The panel members will be selected on the basis of their experience and qualifications. They serve without compensation. A member cannot sit on the panel if the dispute involves an insurance company they are employed by, or if they have even an indirect interest. The panels will be local, taking place in the province where the accident or insured event took place, except where there is agreement to do so elsewhere. If the amount in dispute is less than 10% of the $50,000 limit, then a 1-person panel shall be selected. When there is an issue that falls outside the mandate of the arbitration agreement, but there is mutual consent, the parties can select a mutually acceptable chairperson who in turn selects the other 2 members of the panel. Alternatively, the parties can each select 2 qualified panel members and send their names to the arbitration director, who will draw the chairman from the selected names. The insurance companies may be represented at the hearing by members of their staff. However, this is not a requirement. They must withdraw after presenting their case. The panel's decisions, which are based upon the majority of the members, are binding and final. There is no appeal process. If the decision yields an award, the award is payable within 30 days of the decision being communicated to the insurance company. If one of the parties feel there have been errors made, they can turn to the arbitration chair with their concerns. If you have any questions or concerns about the intercompany arbitration agreement or where to send your application, you can contact the National Arbitration Chair or the local arbitration officer at the CICMA, either through their website, www.cicma.ca, or in care of the Insurance Bureau of Canada at this address.